Good afternoon and welcome to the second of our latest three-part webinar series on construction contracts. Our webinars will provide you with an understanding of three issues of critical importance in the construction industry today, namely contracting for certainty, enforcing rights, and limiting liability. Today's webinar will focus on enforcing rights through payment processes, suspension, termination, and adjudication. Before we begin, there are a few housekeeping matters to address. To minimise background noise, I have placed you all on mute. If you would like to ask questions, please do so using the webinar chat function. In order to keep within the 30 minutes, we will be answering as many questions as we can at the end of the presentation, rather than as we go along. I am Nathaniel Buckingham, and I work in the Construction and Special Projects team based in Edinburgh and specialising in construction and engineering dispute resolution. I'm joined today by Lisa Alexander, a colleague in my team. Our team regularly advises on transactional issues and dispute resolution matters in construction across a wide range of projects and clients, including private and public sector clients, contractors, consultants, and funders. We therefore have a great deal of experience advising in circumstances where employers and contractors are looking to enforce their rights under construction contracts, as well as first-hand knowledge and experience of the adjudication process, which is often used to enforce rights. This experience helps us form the basis of the information we will be sharing with you today. So I will now pass you on to Lisa, who will run through the agenda for today's webinar.
Thanks, Nathaniel. As Nathaniel has noted, today we are focusing on enforcing rights. We will start by looking at how a party's rights under a construction contract can be enforced through the use of payment processes, suspension and termination, and how each of these options can utilise the adjudication process. In the second half of the webinar, we will look at adjudication in more detail, considering recent cases which demonstrate both the potential benefits of enforcing rights through adjudication as well as the possible grounds to watch for whereby adjudicators' decisions may be challenged. One of the most important aspects within any construction contract is undoubtedly payment by the employer to the contractor, and the process that sets out what payment is due and when. The rights to payment that can accrue in a construction contract are usually regulated and enforced through the payment processes. Although payment processes now are much better understood and may seem fairly standard, before legislation was brought in to regulate payment processes under construction contracts, there was often no certainty around the payment requirements. This lack of certainty meant it was very difficult for parties under a construction contract, particularly contractors, to know what rights they had and how they could enforce them. Also, the options for enforcement were generally through court or arbitration, which were both relatively slow and expensive. This was undesirable for a contractor already facing cash flow issues through non-payment. This gave employers or main contractors with subcontractors the upper hand in payment disputes. Today we have a much more regulated payment process under the Housing Grants, Construction and Regeneration Act 1996, known as the Construction Act. This is supported by the Scheme for Construction Contracts, Scotland, or England and Wales regulations, which include default payment provisions that apply if a construction contract does not include adequate payment provisions. One of the main objectives of the legislation is to achieve a higher level of certainty regarding payment under construction contracts and a swifter, less expensive means of enforcing payment rights or resolving payment disputes. As such, under the Construction Act, parties have a right to know what payment is due under the contract and when. A contractor can firstly make an application for the payment the contractor considers is due to him under the contract. The employer, or any specified person, such as the engineer, architect, or even the payee, is then required to issue a payment notice setting out what the employer considers is or was due at the payment date, no later than 5 days after the due date. The employer must then pay the notified sum on or before the final due date for payment, unless they issue a pay less notice setting out their intention to pay less than the notified amount. The final date for payment will be a fixed period after the due date. In the absence of the required notices, the contractor's application for payment becomes the default payment notice, fixing the amount due from the employer to the contractor. If the employer fails to pay the amount due by the final due date for payment, the contractor can commence an adjudication to enforce payment. This is known colloquially as a smash and grab adjudication, seeking quick payment enforcement without a review of the underlying merits of the sums due. The adjudication process will be addressed in more detail later, but the important point to note at this stage is that the Construction Act aims to make payment processes clearer and an adjudication an easily accessible route to enforce payment rights.
The Construction Act also introduced a further option in terms of enforcing payment rights. Contractors now have the right to suspend their works in the event that payment of a notified sum is not made. The original Construction Act gave contractors the right to suspend all of their contractual obligations if they did not receive payment, but this was amended in 2011 to allow contractors to suspend only part of their works. This is really an important practical development because a contractor can react to enforce their payment rights appropriately and proportionally. For example, they could choose not to suspend their construction activities, but rather to suspend other obligations, such as carrying out site visits, or delivering a collateral warranty, or insuring the works. The other party is liable for the costs incurred by the contractor as a result of their suspension. So this change is particularly useful in terms of preventing a default in payment escalating to a halt in the entire construction process, which can cause very complex issues and delays. So we frequently advise contractor clients to consider suspension as part of their armory of enforcing their payment rights. Not every payment infringement will warrant an adjudication, which comes with irrecoverable costs because each party has to bear their own costs. Also, suspension can help to avoid too significant an escalation that termination or adjudication might, and can be a very effective shot across the bows, making the employer know that the contractor knows their rights. Clearly, suspension does not always work, and sometimes may not be sufficient escalation if a contractor considers that significant sums are due but not being paid. For a contractor seeking to enforce rights, the right to suspend works can be taken a step further in the event a party continues to default in their contractual obligations, if the contract contains a right to terminate at the end of a suspension period. Construction contracts will generally contain a termination clause, which will include the specific grounds upon which either party can terminate the contract and how to do so. This is an important tool in enforcing rights and is really where a contract can have considerable teeth. The grounds of termination will vary depending on the type of construction contract, although generally the grounds for standard form construction contracts are very similar. So using the JCT Standard Building Contract and JCT Design and Build Contract as an example, there are separate grounds for terminating the contract depending on whether it is the employer terminating the contractor's employment or the contractor terminating their own employment under the contract. The contract then sets out the consequences of the termination depending on who has terminated and why. The grounds for the contractor to terminate are if the employer defaults, including failing to make payment by the due date in terms of the payment process described earlier, or interfering with or obstructing certification under the building contract. From an enforcing rights perspective, this is clearly a useful next escalation step from suspension. Usually a pre-termination default notice will need to be given before the contract can be terminated. This gives the other party an opportunity to remedy the default, such as non-payment. This can be a useful escalation step. In our experience, it is often enough to prompt a remedy of the default, or at least discussions to resolve matters.
We will now look at the adjudication process in more detail, as it can be a very useful way for a party to enforce their rights and resolve any disputes without having to go to court. Under Section 108 of the Construction Act, a party to a construction contract has the right to refer a dispute arising under that contract for adjudication at any time. Adjudication is a relatively speedy form of dispute resolution. An adjudicator has to be appointed within a week of the intention to adjudicate being notified to the other party. The adjudicator's decision must be made within a further 28 days, though that can be extended by a further 14 days if the referring party agrees, or even longer if both parties agree. The adjudicator's decision will be binding on the parties, unless and/or until the decision is finally resolved in court, because both parties retain a right to have the same dispute decided through litigation or arbitration if the contract provides, subject to any limitations set out in the contract. In those circumstances, the losing party has to pay the amount decided by the adjudicator, and then raise proceedings for the dispute to be decided again by the court, and for repayment of the money they have paid. This is why you may have heard of the adjudication process being described as a system of pay first, argue later. Each party bears their own costs of the adjudication, and the adjudicator can decide who has to pay their fees, generally following success. That can make adjudication less palatable for, say, a small financial dispute, where the cost of adjudication may outweigh the benefit of any sums awarded. An adjudicator's decision is final and temporarily binding. The parties must comply with this decision, and if one party refuses to comply, the other party can enforce the decision through court, for example, in a payment adjudication, seeking a summary judgment that they are entitled to be paid the sum the adjudicator decided was due. There is also no right to appeal the decision under the 1996 Act, and the courts will generally enforce the decision without making any inquiries into whether the decision is correct or not. However, there are two important exceptions to this. The decision can be challenged on the grounds of jurisdiction and natural justice. The jurisdiction ground is effectively a challenge that the adjudicator acted out with the adjudicator's authority. A few examples of this would be if the adjudicator decided something that she or he was not asked to decide, if the contract was not a construction contract for the purposes of the 1996 Act, if the adjudicator's appointment did not comply with the adjudication procedure rules, or even if the dispute had not crystallised and there was therefore no dispute to decide in the first place. In terms of the second ground of breaching the rules of natural justice, this is where the adjudicator, when making the decision, did not act in accordance with procedural fairness. In other words, the adjudicator did not act impartially or give each party an adequate opportunity to make its case. For example, if the adjudicator was biased towards one party and did not take account of submissions from the opposing party, or did not give a party sufficient time to put forward a defence. If a challenge is successful on either of these grounds, the adjudicator's decision will not be enforced by the courts and will be left with no effect. So, adjudication is a quicker and cheaper form of dispute resolution than litigation, and the decision made by the adjudicator is binding and final, unless it is either challenged or decided again through the court or arbitration at the instance of one of the parties. We will now move on to look at a few cases which show the court's reluctance to interfere with an adjudicator's decision, highlighting the benefits of using adjudication to enforce rights under a contract, particularly the payment rights we discussed earlier.
So we will start our case review section by looking at a rather unusual case where it was the successful party in the adjudication who claimed that the adjudicator had acted out with her jurisdiction. In the English case of AECOM Design Build Limited against Stapine Engineering Services Limited in 2017, AECOM subcontracted Stapine to carry out mechanical installation works for Thames Water Utilities under an NEC3 engineering and construction short subcontract. After AECOM terminated the contract, disputes arose between the parties, including how much was due to Stapine on termination. AECOM argued that it was entitled to make deductions from the amount due because of alleged defects in Stapine's installation works. This was therefore a dispute about what rights AECOM had. The dispute was then referred to adjudication to enforce the rights that AECOM said they had to make payment deductions for defects. There were two parts to the adjudicator's decision. Firstly, the adjudicator decided that AECOM was entitled to make deductions for the defects. However, the second part of the decision was that the amount that could be deducted by AECOM was limited to what it would have cost Stapine to rectify the defects. AECOM challenged the second part of the decision in court, claiming it was unenforceable because the adjudicator had acted out with her jurisdiction and/or breached the rules of natural justice. AECOM argued that the adjudicator only had jurisdiction to decide whether or not AECOM were entitled to make deductions for the defects, and not whether that entitlement was limited in any way, which they said was out with her jurisdiction. They also argued that they were not given adequate opportunity to make submissions on how the deductions should be calculated. The court rejected both of these arguments. On the ground of natural justice, the court held that the adjudicator decided a point of importance on the basis of the material before her, and it was irrelevant that AECOM had not made submissions on it, as they had been provided with sufficient opportunity to do so. Regarding jurisdiction, the court held that an adjudicator is permitted to reach a decision on a point neither party made submissions on. The scope of jurisdiction can be wider than the referral notice or the submissions. In applying a wider jurisdiction, an adjudicator is not necessarily acting out with their jurisdiction, even if the decision made on that point is wrong, in fact or in law. In the court's judgment, the case of Steelite Construction Limited against Vascroft Contractors Limited was referred to, and in that case the judge said, generally, given the limited timetable allowed by adjudication, on the question of the scope of the referred dispute, the courts are going to have to give adjudicators some latitude and not take an unduly restrictive view. That quote will no doubt give some comfort to any adjudicators we have in the audience today. These cases uphold the adjudication process by supporting the finality of an adjudicator's decision and demonstrating the reluctance to unduly restrict the jurisdiction of an adjudicator in order to avoid enforcement, unless there has been a clear breach of jurisdiction or natural justice. As Lisa mentioned earlier, an adjudicator's decision will be temporarily binding unless it is successfully challenged on either of the two grounds we've looked at. Therefore, although it is only binding insofar as it is not finally decided in court, a successful challenge on grounds of jurisdiction or natural justice is rare. The difficulty in challenging an adjudicator's decision is well known. However, in 2015, this understanding was somewhat blurred by the case of Caledonian Modular Limited against Mars City Developments Limited. This was a very rare case where an adjudication enforcement hearing was used to determine a substantive part of the adjudicator's decision. In other words, the decision was challenged on its merits rather than just jurisdiction and natural justice in an enforcement hearing. The court held that if the issue of merits is a short and self-contained point which requires no oral evidence, then the court can review it during an enforcement hearing. Despite the judge in that case stressing that this procedure will rarely be used, and he also said in 99 cases out of 100, the merits of a dispute would not be capable of preventing the enforcement of an adjudicator's decision. Notwithstanding those two comments, the case did somewhat open the door for parties attempting to use this procedure. Unsurprisingly, there was an increase in the number of challenges on substantive points brought to court from parties disagreeing with an adjudicator's decision in enforcement proceedings. However, since this decision, the court has tried to reduce its impact and application. The court's disapproval was clarified in the more recent case of Hutton Construction Limited against Wilson Properties London Limited in 2017. The court reiterated that a losing party simply believing the adjudicator reached the wrong decision will almost never be a successful argument for resisting enforcement. The judge held that the arguments in this case were an attempt to revisit every issue raised in the adjudication and additional points not initially raised simply because Wilson disagreed with the adjudicator's decision. The judge went on to say that it cannot be right, absent any consent from the claimant, to let the defendant shoehorn into the time available at the enforcement hearing the entirety of that adjudication dispute. Such an approach would mean that, instead of being the de facto dispute resolution regime in the construction industry, adjudication would simply become the first part of a two-stage process, with everything coming back to the court for review prior to enforcement. The court's commitment to limiting the impact of the Caledonian case reinforces the court's reluctance to interfere with the correctness of an adjudicator's decision.
So far, we have seen that adjudication can be a highly beneficial means of enforcing rights, with the adjudicator's decision being final and temporarily binding on both parties. However, it is important to consider possible grounds where enforcement of the decision can be suspended. A party can resist enforcement through what is known as a stay of execution. This stops the enforcement process and will therefore prevent an adjudicator's decision being enforced for a period of time. This could be because certain matters have occurred or information has come to light since the date of the decision. This is often based on the financial position of the winning party. For example, an award is made in favour of a party by an adjudicator. After the decision is made, it comes to light that the financial position of the winning party is such that if a final court decides that the winning party were not entitled to all or part of that award, the winning party would not be able to repay that sum. In that situation, the other party could try to resist enforcement of the adjudicator's decision and ask the court to pause proceedings while the claimant's financial standing is assessed. Although a stay of adjudication is often based on the claimant's financial position, the case of Grosvenor London Limited against Aegon Aluminium UK Limited in 2018 added fraud as an additional ground. In this case, Aegon appointed Grosvenor to install cladding for a new hotel in Southampton. The works were delayed and the matter was referred to adjudication. The adjudicator found in favour of Grosvenor and awarded them £553,958.47. Aegon resisted enforcement of the adjudicator's decision, claiming that the sum awarded to Grosvenor was based on fraudulent invoices. The court granted Aegon a stay of execution. There were questionable disparities between Grosvenor's 2016 and 2017 accounts, which Grosvenor provided no evidence to rebut in the hearing. The court found that it was necessary to look into the fraud allegations further and decided therefore not to enforce the adjudicator's decision until that had been undertaken. The court said that if the evidence demonstrates that there is a real risk that any judgment would go unsatisfied by reason of the claimant organising its financial affairs with the purpose of dissipating or disposing of the judgment sum so that it would not be available to be repaid, then this would also justify the grant of a stay. The court stressed that this new ground will apply to very few cases and will be extremely rare. However, it will likely add a new avenue for parties seeking to avoid enforcement of an adjudicator's decision. In our experience, it is increasingly common to see fraudulent claims and evidence being presented. To conclude on this section, it should be noted that a decision by an adjudicator cannot be relied upon until it is enforced, and there are potential grounds for enforcement to either fail if a jurisdiction or natural justice challenge succeeds, or be suspended if there are financial standing or fraud issues. Nevertheless, these grounds are strictly limited, and usually the winning party can obtain a swift judgment supporting the adjudicator's decision and then utilise the normal course enforcement procedures if the judgment is not complied with. However, after that, a party can have the entire dispute decided again in court, subject to any contractual limitations on that right. In theory, that could mean a reversal of the adjudicator's position and the winning party having to repay the other party. However, that is unusual. Adjudication is usually a good way to enforce rights under a construction contract, and the courts are generally reluctant to interfere with adjudicators' decisions.
Okay, so we have now come to the end of the presentation, which we hope has been useful and interesting. Apologies for the slight disruptive noise earlier in the webinar. We do still have a few minutes to answer any questions, so if you haven't already done so, please type your questions into the chat box now. So while you are doing that, I will just take the opportunity to remind you that the final webinar in this series is on Tuesday the 27th of November, when we will be looking at limiting liability in a contract. The webinar will start at 1 p.m, and if you haven't already signed up to these, then please do so by visiting the News and Events section of our website. This webinar has been recorded and will be available on our Vimeo site shortly. So if you know of any colleagues who haven't been able to participate today, or if you think this will be useful for anyone, then please let them know. We will be circulating details of the recording to participants after the webinar. So just have a look at the questions. So we do have one question, which is I suppose it's more of a strategic question actually, which is whether it's better to escalate matters gradually in terms of enforcing rights, or better to go straight to adjudication. And I suppose the answer to that is it does depend somewhat on the dispute itself, and I suppose the scale of the dispute, if it's of monetary value, whether it's a big amount of money or a small amount of money, or whether it's for some other right that you're looking to enforce. So I suppose that is specifically a strategic question. The two options really then are, you could escalate matters quite gradually, and this can often be a useful way at the early stages of a project, or where there's some smaller disputes. So for example, you could escalate by starting with perhaps writing a letter to the other party, perhaps arranging a meeting to discuss the issues. Then, as we've talked about earlier today, you could step that up to a threat of suspension if, for example, payments are not being made. And even pre-termination, you could issue a default notice, which is the step prior to termination, which itself is an escalation step, because often in our experience we find that when a termination default notice is issued, it can often prompt action, even if action hasn't been taken before. In other words, for the party in default to actually correct things. I suppose the value of escalation in a more gradual way is that you can often continue with the works, the project can continue, you can sort problems as they arise without becoming entrenched or completely falling out, and the escalation can then be a little bit more proportionate to the issues that are being experienced, and hopefully you can simply tackle each issue as it arises, escalate appropriately, and then get on with the project until the next issue arises. I mean, in the alternative, though, going straight to adjudication sometimes is a good option. It can result, for example, if there's a significant payment that has not been made and no payment notices have been issued, an adjudication can result in a quick win, which could set down a marker for how the contract should be run. Now, as I say, particularly for payment, it might be that a contractor wants to set down that marker early to say, you know, we know our rights, we know how to enforce them, and we're not going to accept the payment process not being followed correctly. And you know, that might force an employer or the other party to then get on side in terms of the payment process and for the rest of the project, which can be helpful as well. So I suppose, as I say, that's quite a strategic question. It does depend on the dispute, and of course we would say this, but I suggest that in any dispute situation you do seek advice and look at the strengths of your position in any dispute or any right that you're looking to enforce, and also to discuss the strategy and the best approach really to enforcing that particular right. Okay, well, I think that's us nearly at half an hour, so I think we'll call that time up for today. I do hope that you have enjoyed this webinar and found it informative and useful, and we look forward to welcoming you to our next webinar at the end of November, when we will look at limiting liability in some more detail. Thank you.